Good morning, everyone.
Good morning. Sorry, I hope I'm in the right room.
Hello. Yes, Rishabh, you are in the right room.
Good morning, everyone, once again. Would you like us to introduce ourselves in the chat box, or is it by voice?
Being recorded.
Good morning. Just checking if my fellow judge is present on the bench.
Hi, I'm here. Hi, Karen, right?
That's right.
Hi, Karen. How are you? This is Rishabh.
I'm well, thank you. Okay, perfect. So the bench is complete.
Perfect, thank you. Would you like us to introduce ourselves?
Yes, please.
Just is
Hello.
everyone here? Sorry to interrupt. Is everyone here for each party? Because I only see like not like 5 names or something.
I believe from the Lebanese University side, we are complete since our team is only composed of 2 people. So I will be the appellant side, and I will be presenting both grounds of appeal.
And for the respondent? Is the respondent team complete as well?
I don't think so. Sorry, Gina. You mentioned that it's you and sorry. Could you repeat? I think I missed out something there.
Yes, my team is composed of me, Gina Matar, and my teammate Safa, who is the respondent. So on the appellant side, in this
Okay, I don't think your
current,
teammate has joined.
yes, I believe he will be joining the other hearing since I will be presenting the appellant side on both grounds. So I will be presenting both the senior and junior appellant.
You'll
If
be
that
both
Oh,
is
senior
okay.
and junior.
okay.
Is that correct?
Excuse me?
You'll be both senior and junior. Is that correct?
Yes, yes, exactly.
All right, then that's fine.
Thank you.
So you are the appellant?
Yes,
And
both the senior and junior.
Okay, all right. And the respondents, we're still waiting for them.
Yes.
The respondents have joined. I'm the junior counsel for the respondent.
Excellent.
And I am the senior respondent.
Okay. Excellent. Well, Are we waiting on anybody else, or can we begin? Mr. Jogani.
Yes, we can begin. We can begin. Sorry, I thought I was speaking. I was on mute.
Perfect. So court is in session. We are ready for your arguments.
Thank you. If that's okay, I would like to start by introducing myself. My name is Gina Matar. I am both the senior and junior appellant. I will be providing before the honorable case both grounds of appeal. The first ground of appeal being related to the jurisdiction, and the second ground of appeal being related to the contract point. The council seeks permission to begin with the statement of submissions.
Yes, can I ask please that when speaking, cameras are turned on?
I am afraid that I have a connection problem in Lebanon. The connection is a bit difficult, so that would be interfering with my speaking.
Okay, noted.
Sorry.
Please proceed.
Okay. Before presenting my submissions, I will state the essential facts of the case for the benefit of the court. First of all, both the appellant and respondent are users of Clavity, a digital platform that uses a distributed ledger hosted across hundreds of digital nodes in many countries, including a node within the DIFC. Clavity permits undertaking algorithmic trading on the platform through autonomous and deterministic programs. The respondent resides in Dubai, UAE, but not within the DIFC, and undertakes trading through Alpha program that automatically buys a cryptocurrency called Yapple, and the best possible price available at Clavity. On the other hand, the appellant resides
Sorry,
in the
apologies, Ms. Gina. Can you just try turning your camera on for a few minutes and let's see what happens?
I apologize. I sincerely apologize, but I have tried it before and it has caused several connection problems.
I would like you to please try it now, if that's okay with you.
Of course, I will try. Just a second, please.
Thank you very much.
I again present my sincere apologies to the judge since this is making difficulties, both technical and connection. If I may proceed without the camera on, I would be very grateful for that.
It's going to be difficult for us to grade your presentation without being able to see you.
I apologize once again. There is really nothing I can do about it.
Okay, thank you. But can you confirm whether you're reading?
I have my notes, but I am, of course, speaking without reading.
Okay, thank you.
Would the court like me to proceed, or is there any problem with that?
Yes, please do.
Okay, thank you. The respondent resides in Dubai, UAE, but not within the DIFC, and undertakes trading through Alpha program. On the other hand, the appellant resides in the Sultanate of Oman and undertakes trading on Beta program. Beta is coded in such a way that if there are no other users offering to sell Yapple on the Clavity platform, Beta automatically offers Yapple for sale at a highly inflated price. As Clavity's software underwent a routine upgrade, there was an error, so the appellant and respondent were the only users permitted to trade on the platform. In the result, Alpha and Beta automatically concluded a trade in which the appellant sold 100 Yapples to the respondent at a price 250 times greater than the prevailing market price. Seeking a declaration that the previously mentioned trade is void for unilateral mistake, the respondent issued proceedings in the DIFC Digital Economy Court. In return, the appellant challenged jurisdiction and argued that there could no be relevant mistake within Article 37 of the DIFC contract law. The Court of First Instance dismissed the appellant's application on the basis that the IFC Court, first of all, had jurisdiction under Article 5A1B of the Judicial Authority Law, as Clavity operated through a distributed ledger and one of its nodes was within the DIFC. And second, for a trade to be void according to Article 37(1)A of the DIFC contract law, it is sufficient that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. I would like to respectfully submit my submissions on the first ground of appeal.
Sure.
Thank you. The first ground of appeal is related to the lack of jurisdiction. It is my respectful submission that the first instance court erred in concluding that because Clavity operated on a distributed ledger with a node within the DIFC, the court had jurisdiction over the disputed trade. I would like to present two submissions. My first submission would be on the basis of the case of AA versus persons unknown and others. And my second submission on the basis of case Iron Science versus persons unknown. At common law, English courts now consider cryptocurrency a form of property. This is decided in the case of AA versus persons unknown in the England and Wales High Court as a case number CL 2019-000746. The court decided that, and I quote, "I consider that a crypto assets such as Bitcoin are property. They meet the four criteria set out in Lord Wilberforce's classic definition of property in National Provincial Bank versus Ainsworth, as being, first of all, definable, identifiable by the third parties, capable in their nature of assumption by third parties, and lastly, having some degree of permanence," end of quote. That too was the conclusion of several courts, such as the Singapore International Commercial Court, and in addition to the New Zealand case of Risco versus Cryptopia. In determining the relevant jurisdiction to rule this exchange of property, as we have mentioned, it brings me to my second submission by the English courts in the Iron Science versus Persons Unknown case issued on the 21st of December 2020. The High Court of Justice, in the case number CL 2020-00044.
Sorry. I mean, could you tell us a little bit about the case that you're referring to?
Yes, of course.
So what exactly is the case? Who were the parties?
Excuse me, can you hear me?
Who were the parties and what exactly was the issue before the court? Can you please help us with that?
Yes, and the yes.
I'm sorry for interrupting. Just a second. So the Lebanese University is the appellants. So you should be arguing the other way around. So your client is the Lebanese University. Your client is Mr. Payne, Leith Payne, and not Rajrani. You have said that DIFC courts have jurisdiction. You should be saying that DIFC courts do not have jurisdiction. So basically, the Middlesex University Group F should be saying that DIFC courts have jurisdiction because we are the respondents. I think you have got a little confused regarding the appellants and the respondents.
Apologies, may I ask who is speaking?
This is Mohammed Twaib.
And you are a fellow judge?
I'm the junior. No, sorry, I'm the junior counsel for the respondents.
Okay, thank you for your comments, but we please ask and I think I speak on behalf of my co-judge on this, that parties refrain from speaking out of turn, especially without seeking permission of the court prior.
Extremely sorry for it. I thought there was a confusion, so I thought to clarify it. My bad.
Thank you for bringing that to our attention.
Uh,
The court will
may
take a
the
short
appellant,
recess. Pardon?
may the appellant please seek request to answer my fellow counsel on this matter?
Yes.
Yes, I would please like to justify that I am, in fact, representing Mr. Lane, and therefore I am, I am submitting that there are no grounds for jurisdiction of the DIFC court. Thank you.
Okay.
The court invites the respondent to comment at this time, if there is a comment.
Yes. So, so you have previously said that the appellants have previously said that the DIFC courts have jurisdiction, and they have also stated that the transaction or the disputed trade which occurred was a result of an error. So, I think there is confusion from the appellant side.
Okay, thank you.
May I please just finish the matter concluded, just a few words?
Apologies, 1 second. I'm waiting to hear back from my co-judge on whether a recess is in order at this time.
Sorry, a recess for what? I'm very
To
confused.
discuss,
Oh, sure, we could.
or with, or
We have to leave.
if,
Or we can just use the chat and then
that's fine.
let them proceed. There is limited time. Let's not waste it.
Yes, okay. You may proceed. Thank you.
Thank you. I would just please like to identify that what I said regarding the jurisdiction of the DIFC falls in the essential background that I mentioned before and does not mean my grounds of appeal, since my grounds of appeal are stating that the DIFC courts do not have jurisdiction on this current matter. Thank you.
Thank you. So that concludes your point on jurisdiction.
If I may complete my point, I still have the second submission on this matter.
Okay, please proceed.
Thank you. The second submission is regarding the High Court of Justice, Business and Property Courts of England and Wales that considers in the Iron Science versus Persons Unknown case that lacks status of a crypto asset is the place where the person or company who owns it is domiciled. The mentioned judgment reflects an analysis of Professor Andrew Dickinson in his books Cryptocurrencies in Public and Private Law, that the judicial authority before which a claim related to crypto assets is to be heard, is the place where the relevant participant in the Bitcoin system is domiciled. Therefore, and based on all the previously mentioned, it is my respectful submission that the establishment of the DIFC jurisdiction under Article 5A(1)(b) of the Judicial Authority Law is false. And upon observation of the place of domicile of the appellant and the respondent who owns a crypto asset considered a property, it is evident that although the place of domicile of the respondent is within Dubai, the United Arab Emirates, neither the appellant nor the respondent is located within the DIFC. Therefore, it is my respectful submission that the DIFC courts lack jurisdiction over the disputed trade. And that would be the end of my submissions regarding the first ground of appeal. Thank you.
All right. Respondent. Sorry, Karen, do you have any questions for the appellant?
No, no questions at this time. Thank you very much.
Do we have the respondents in your lead?
Yes.
Sure.
May I begin?
Yes, please.
Okay. May it please the court, as introduced by my learned friend, my name is Jafreen Aftab, and I am the senior counsel for respondent Ms. Rajrani. I will be assisted by my learned junior, Mr. Muhammad Toyib. I would be addressing your lordship on the first ground of appeal, namely that the first instance court error in concluding that because Clavity operated a distributed ledger with a note in the DIFC court had jurisdiction over the claim by Mr. Arsrani against Mr. Bean under Article 5A1B of the Judicial Authority Law. My learned junior will be addressing your lordship the second ground of appeal, which say that the first instance court error in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Rajrani shows that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that dispute trade was the result of an error. My lord, I have two submissions to make. Firstly, since Clavity operates a distributed ledger with one of its notes in the DIFC, it can be concluded that the transaction has been wholly or partly performed within the DIFC. Thus, DIFC courts have jurisdiction in this case. Second, since the parties had not chosen the legal jurisdiction before entering into the contract, thus by default, the DIFC laws would be applicable on both parties. Moreover, DIFC courts can exercise enforcement regionally through the GCC convention, which applies to Oman as well. If it pleases your lordship, I shall now begin with my first submission. The respondent submits that the judge of the first court of instance did not err in concluding that the DIFC courts had jurisdiction in this case, as Clavity operated a distributed ledger with one of its notes in the IFC. The judicial authority law states that the court of first instance shall have exclusive jurisdiction to hear and determine any civil or commercial claims and actions arising out of or relating to any incident or transaction which has been wholly or partly performed within DIFC and is related to DIFC activities. Since Clavity operates a distributed ledger with one of its notes in the DIFC, it can be concluded that the transaction has been wholly or partly performed within the DIFC. Moreover, virtual assets like cryptocurrency are categorized as one of the DIFC's activities, as the DIFC, a prominent free zone within the UAE, has its own regulatory framework for virtual assets under the jurisdiction of the Dubai Financial Services Authority. My lord, I would like to bring to your notice the case of the Lotus case reported in the year 1927. For the benefits of your lordship, the facts of the case are as follows. In 1926, a French steamboat, the SS Lotus, collided with a Turkish steamboat, the boat's port. This resulted in the sinking of the Turkish boat and the death of 8 Turkish nationals. Turkish authorities instituted criminal proceedings against a French officer on duty abroad, the SS. This case established that a state will have jurisdictions over incidents that were completed in its territory, even though some elements constituting the civil wrong or the offense took place abroad. Thus, it can be implied that since Clavity operates a distributed ledger with one of its nodes in the DIFC, it can be concluded that the transaction and this incident of disputed trade has been wholly or partly performed within DIFC, and thus DIFC courts have jurisdiction in this case. My lord, I will now be moving to my second submission. The official DIFC court's website states that the DIFC laws allow.
Apologies, just one question. Sorry, I think I had trouble hearing. What was the conclusion of what is the relationship between the Lotus and how it applies to the facts at hand here?
Okay, can I go over it again?
You don't need to go over the whole thing again. What
Okay.
is the principle from the Lotus case that is relevant to our proceedings here today?
The French steamboat, it collided with the Turkish steamboat, which resulted in the death of 8 Turkish nationals.
So those are
And
the facts of the case, and I'm asking
yes,
you what the principle of the case is. What is the legal principle that came from that case?
um, my lady, can I haven't gone through the principles.
Okay, so maybe just to rephrase the question, why is the Lotus relevant for
Okay.
our fact pattern here?
Okay, so the incident, it took place in the French boat. It collided with the Turkish boat. So it took place in France, and in our case, the incident took place in the DIFC.
What is the incident here that you're referring to?
The French boat collided with the Turkish boat, and which resulted in the death of 8 Turkish nationals in France.
Yes, but in our fact pattern, what is the incident?
That it took place abroad, and they have jurisdiction over it.
Okay, and in your client's case, what is the incident that is comparable to the incident of the Lotus case?
Pardon, can you please repeat the question again?
Yes, happy to. In you said that the incident in the Lotus case took place in France. That was one of the findings of the court, and that's relevant part of the case of this judgment that has prompted you to introduce it now in making your argument. So I'm asking you, what is the incident in your client's situation
Okay.
that is
So
comparable? Yeah.
100 yapple from Oman for to the DRC. So in our case, sorry, can I just take 1 minute to frame my statement?
Oh, of course. Yeah, no worries.
Okay, thank you.
You may discuss with your co-counsel.
Okay.
Just take 1 minute. I'm timing you.
Okay, thank you so much. May I speak?
Yes.
Okay, so in our case, the transfer of 100 rappels from Mr. Payne to Rajrani was located in DIFC, while Mr. Payne was in Oman. That would be the relevance.
The transfer occurred in the DIFC. Is
Yes.
that? Can you point to a paragraph of the fact pattern that states that?
The case of the case.
Yes.
Okay.
I guess is this information directly from the facts of the Moot problem, or is this your interpretation of the facts?
The fact of the Moot problem.
The fact of the Moot problem says that the transfer took place in the DIFC.
Yes, the node was at DIFC.
But okay, so the node was in the DIFC, and for you that means the transfer was in the DIFC.
Yes.
But there were also, this is one node of many nodes all over the world.
Yes. Can I speak to my counsel?
Yeah, we'll take another. These are hard questions, so
Okay, thank you so much.
another 30 seconds, and then we can. I'll ask you to briefly summarize the rest of your argument. Thank you.
Okay, thank you.
Council, I think if it would be fine if you choose to come back in rebuttals. Out of the interest of time, I'm just concerned about time.
Yes, sorry. I'm ready to speak.
Oh, great. Okay, thank you.
Okay, so from the facts of our mood problem, we can tell that there was a node in the IFC, and it is not mentioned that there is a node in Oman. So it can be implied that the transaction took place in the IFC. Yeah.
Good. Thank you. If I can ask you, please, because I have been very interventionist and taken up quite a bit of your time, if I could ask you to please summarize and conclude. Thank you very much.
Okay. Can I move on to my second submission, or do I
Yes,
just?
of course.
Okay. 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 My lord, I will now be moving to my second submission. The official DIFC court's website states that the DIFC laws allow for any institution operating within the DIFC to select a legal jurisdiction of its choice, other than the DIFC, when entering into contracts. However, in the event that parties do not do so, the DIFC laws will be applicable by default, and they can file a case in the DIFC courts. Since Clevity operated a distributed ledger with one of its nodes in the DIFC, it can be implied that a part of Clevity operated in DIFC. And since the parties had not chosen the legal jurisdictions before entering into the contract, thus by default, the DIFC laws would be applicable on both parties. Through the UK-Netherlands Agreement 1999, it was established that a state can exercise enforcement jurisdiction within its territory for a specific purpose. Judgments of the DIFC courts can be enforced locally, regionally, and internationally through treaties such as the GCC Convention, which apply both to Oman and UAE as well. Article 4D of the GCC Convention states that in the event of non-contractual liability, if the act, the subject matter of the liability, occurred in the territory of such state, then the courts of the state in which a judgment is issued shall be considered to have jurisdiction. Thus, DIFC courts have jurisdictions as one of the nodes of Clevity is located in DIFC. Hence, it can be implied that the act transaction took place at DIFC. In addition to that, my lord, I would like to bring to your notice the case of Corinth Pipeworks SA and Barclays Bank, reported in the year 2011. For the benefits of your lordship, the facts of the case are as follows. The appellant claimed damages against the respondent for a tort committed outside the DIFC but sued the respondent in the DIFC court invoking Art 5A1 of Dubai Law number 12 of 2004 on the grounds that the respondent, as well as a registered company in the DIFC, was accordingly a center establishment under Article 5A1A. The court held that the DIFC courts did not have jurisdiction to hear a claim against Barclays Bank, even though one of the branches of Barclays Bank was located at the DIFC, because the dispute involved the activities of the Barclays Bank located in Jebel Ali, which was not related to the activity of the DIFC branch of the Barclays Bank. This case can be distinguished from our case as all the nodes of Clavity complete transactions, thus performing the same function. Hence, DIFC laws are applicable in this case because Clavity does not have different branches or nodes performing different functions. Mr. Payne has directly accepted that the DIFC laws are applicable to this case by appealing against the judgment of the Digital Economy Court, which is a division of First Court of Instance. Moreover, cryptocurrency is not regulated by any of the laws in Oman. Hence, Oman courts cannot apply any laws or regulations to protect the consumers from the risk of trading virtual assets. Thus, the appellant, Mr. Payne, who currently resides in Oman, cannot argue that Oman courts have jurisdiction over this case. It is the submission of the respondents that the Court of Appeal follows the decision made by the Court of First Instance. The DIFC should have jurisdiction over the claim and dismiss the appeal. My Lord, I will now be moving to my conclusion. In conclusion, it is the submission of the respondent that the judge of the First Court of Instance did not err in concluding that the DIFC courts had jurisdiction. My learned junior, Mr. Mohammed Tuayub, will now address your Lordship to the second ground of appeal. I would like to invite your Lordship to hold the decision made and dismiss this appeal. With that, your Lordship, this concludes my submission for the respondent.
Thank you.
Thank you.
Do you have any questions, Kat?
Not at this time. Are we waiting to hear from the junior counsel for respondent?
No, is the junior counsel for, I mean, the counsel for appellant not sort of re-arguing the balance points?
Yes, if I can state the rebuttal regarding this first ground of appeal, it would be my honor.
Yeah, I think let's hear you on what points you have in rebuttal.
Okay.
Yes, thank you. The respondent states that the fact that the DIFC has one of its nodes in a server based within the DIFC implies that the transaction has occurred within the DIFC. However, it is the decision of the English courts that the location is completely irrelevant in the relation to the establishment of the jurisdiction. According to the mentioned court solutions, such as that of Iron Science versus Persons, the jurisdiction of a crypto asset is the place where the person or company who owns it is domiciled, and therefore, as we can see of the case, that neither of the parties is domiciled within the DIFC.
Thank you, counsel.
Therefore,
Oh, sorry. Go ahead.
excuse me. Therefore, it is my respected submission that the court excludes the possibility of the jurisdiction of the DIFC for the current trade. Thank you.
Thank you, counsel. You mentioned a case from the English courts. Can you please let us know the facts of that case and its name?
Yes. The case is the case of Iron Science Limited as a claimant versus Duncan Jones as a second claimant versus persons unknown. The case is before the Royal Courts of Justice The solution is issued on the 21st of December on 2020.
Thank you.
Thank you. May I ask the court if I can state briefly my appellant side grounds of appeal based on the second ground of appeal related to the contract point?
Yes, of course. Allow me please just to confer with my co-judge.
Of course, thank you.
Is this acceptable to you?
Yes, yes, it is.
Okay, thank you. Please proceed.
Thank you very much. For the second ground of appeal, it is my respectful submission that the first instance court erred in concluding that it is sufficient for the purpose of avoiding undisputed trade under Article 37(1)(a) of the DIFC contract law that only a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. I built this ground of appeal on two submissions. The first submission is related to Article 3.5 of the UNIDROIT Principles of International Commercial Contracts issued in 2004, which Article 37 of the DIFC contract law is based upon. The commentary to that article makes clear that the fact that a reasonable person would consider the circumstances assumed to be essential is not sufficient to consider a mistake relevant with view to avoidance of the contract, since additional requirements concerning both the mistaken and the other party must be met if the mistake is to become relevant. In this relevant idea, the commentary explains that a mistaken party may avoid the contract only if the other party satisfies one of the four conditions. These four conditions are that both parties are labored under the same mistake, the error of the mistaken party is caused by the other party, the other party knew or ought to have known that the error or the mistaken party and that it was contrary to reasonable commercial standards of fair dealing, and D, the party other than the mistaken party had not reasonably acted in reliance to the contract. On another note, and relating to my second submission, the commentary provides that speculative contracts involving conflicting expectations of future developments, such as those concerning prices and exchange rates, may not be avoided on the ground of mistake, since the mistake would not be one of facts existing at the time of conclusion of the contract. In this case, the disputed trade involves a cryptocurrency that the price of which varies on the Clavity platform, and therefore, this trade constitutes a speculative contract. Therefore, it is my respectful submission before the court that the first instance court erred in concluding that it is sufficient for the purpose of avoiding a disputed trade, that a reasonable trader with knowledge of the circumstances would have concluded that the trade was the result of an error, and therefore that there could not be grounds to avoid the disputed trade. Thank you very much.
Thank you very much. Hello, junior counsel for respondent. Now it's your turn.
Thank you.
I think you're muted.
Oh, okay. Can you hear
Looking
me right
forward
now?
to hearing your arguments.
Am I audible? Am I audible?
Yes, I can hear you.
Okay, thank you. May it please the court, my name is Mohammed Twaib and I'm the junior counsel for the respondents, Ms. Razrani. I will be addressing your ladyship on the second ground of appeal, which is as follows. The first instance court made an error in concluding that for the purpose of the claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, Section 1, Subsection A of the DIFC contract law with Ms. Razi, show that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. Your Honor, this concludes my second ground of appeal. I have two submissions to make for the second ground of appeal, which are: the first submission is disputed trade has occurred due to a mistake, and my second submission is that any reasonable person with the knowledge of the transaction would have concluded that the transaction occurred due to a mistake. For the benefit of your leadership, I will begin with my first submission. So, according to Article 37, Section 2 of the DIFC contract law, it stated that a party may a party cannot avoid contract only if it was grossly negligent in committing the mistake. So over here, my client did not commit any mistake, nor did he nor did he grossly and negligently commit any mistake. And it's written, and the subsection B states that if the mistake relates to a matter in regard to which the risk of the mistake was assumed. So in this case, it was highly unforeseeable that the cryptocurrency coin would, the price of the cryptocurrency would be, excuse me, and the price of the cryptocurrency would suddenly increase 250 times. So it was highly unforeseeable. Even if we had to consider the risks, it is highly unforeseeable for my client, Mr. Payne, to assume or even think that within a few hours or within a day that the price would increase by 250 times. So I would like to move on to my first case. In Bell and Lever Bros Limited 1931, it was established that in order for the contract to be void for mistake, the mistake must involve the actual subject matter of the agreement and must be of such a fundamental character so as to constitute an underlying assumption without which the parties would not have entered into the agreements. So basically, at common law, the mistake which occurred must be very significant and important. The parties would, because of which the parties would not have entered into a contract if they were aware of the mistake and the circumstances. So similarly, in this case, Mr. Razi would, if Ms. Razi knew that, if Ms. Razi knew about the circumstances of the whole transaction, she would have never entered into the contract because it's highly unreasonable and unlikely for any person to, for any individual to buy cryptocurrencies at a price which is 250 times higher. So my next case is the Collins and Shields case. So in this case, I would like to give you a brief facts of the case. Mr. Hartog was selling 30,000 Argentinian hate skins, basically rabbit skins. So usually it is sold at, so usually the skins are sold per skin and not on a pound or a kilo basis. It's sold on the basis of per skin. So in this case, the contract was signed. In this case, the contract was signed, and the what do you call? And the skins were sold per skin. instead of it being sold per kilo. And there was a huge what do you call, in this case there was a huge mm, in this case the price.
You're doing great, counsel. Don't worry.
Yeah. So usually these skins are sold per skin instead of per kilo, and in this case, when it was sold per skin and instead of it being sold per kilo, there was what do you call? There was a loss. There was like huge what do you call, fine monetary difference. So instead of them getting 100,000, they got 300,000 pounds. So there was like a huge loss. There was a decrease in 1/3 of the price. Yeah.
Okay.
So yeah. So basically, in that case, if Hartog would have, if Collins, excuse me, in the previous case, if Collins would have known that the skins were being sold per skin basis instead of per kilo basis, he would have never got into the contract. So what I'm trying to imply is that if Ms. Razi knew that 100 coins of Yapple would cost her 250,000 US dollars, she would have never entered into a contract with Mr. Payne, as it was a very highly inflated price. And the prevailing market price for one Yapple is the name of the cryptocurrency. The prevailing market price for one Yapple was $10, and so 100 Yapple coins would be $1,000. But after the but after the transaction and due to the high inflation of the price, the the price increased to 250,000 US dollars. So instead of it being 1,000 US dollars, it increased to 250,000 US dollars. So at any cost, my client, if she would have known the circumstances and the price, because the price of the cryptocurrency was the most essential part of the contract. If she would have known that the price has increased by 250 times, she would have never got into the contract. So my next my next case is Jila LLC and Jilad LLC 2016. This is a DIFC case. It was a small claims tribunal case. It was the 84th case in 2016. So if I may give you the facts of the case. So in this case, the claimant was the landowner and he was renting out a commercial unit to the defendant, who is about to open a beauty salon shop in DIFC. The defendant's representatives went to inspect and examine the location and the size of the unit. However, one of the former employees of the claimant made a mistake and sent sorry.
Please proceed. I'm not sure where that sound was coming from.
Oh, okay. So one of the former employees of the claimant made a mistake and sent the wrong location and the size of the unit to the defendant, and the contract was signed. When the defendant realized that the unit shown to him earlier and the design of the unit sent by the claimant later were two different units with two different locations and sizes, he expressed his concern, but the claimant did not make any changes. And since the defendant did not get his desired unit at the desired location, he was not able to make enough profits to pay his rent to the landowner. Then the landowner, who is the claimant, he sued the defendant for breach of contract for not fulfilling his obligations, which is to pay the rent of 220,000 dirhams annually. And the claimant, who is the landowner, he also sued for the bounced check. Although he knew this, although he was aware of the circumstances that um, because the defendant didn't get his desired unit or his desired shop, he was not able to make enough profits. He was barely able to meet the requirements to pay the rent. So the total claim the claimant made was for 300,000 dirhams, whereas the defendant, he was counter arguing and he was suing the claimant for 380,000 dirhams from the claimant for reimbursement of the lost income. during the elongated fit out period, and because he didn't earn enough profits because the location the was a fundamental part of the contract, and because he didn't get his desired unit, he was not able to earn enough profits, and he was not able to pay uh, the employees their salary. So he was claiming 380,000 dirhams for the elongated fit out period and for the salaries of the employees of for 3 months. And he had some other requests as well, but then since those are not material facts of the case, I would not be stating it. But thus the DIFC courts stated that under the DIFC contract law, the defendant can only escape its obligations under the lease agreement if it can demonstrate that when the contract was concluded, the mistake regarding the location and size of the premises was of such importance that a reasonable person in the same situation as the defendant would not have concluded or would not have got into the contract if the true state of affairs had been known. And the courts also stated that the judge I am of the view that a reasonable person would take the view that a mistake regarding the location and size of the unit is of the utmost importance. And in addition, the claimant had caused the mistake by identifying, it was the claimant's mistake for identifying the wrong unit in correspondence with the defendant. Thus, the DIFC courts held that the defendant can hold the contract void as there was a unilateral mistake as to the size and location of the unit, which was the which was the essence of the contract. Excuse me. However, since there was no application by the defendant to void the lease agreement under DIFC contract law, the lease agreement remains in effect, and defendant shall be provided with the compensation which he seeks for. Thus, it can be concluded that where the mistake is crucial to the fundamental terms of the contract, a reasonable person in the same situation as the defendant would not have concluded it at all if the true state of affairs had been known. So, in conclusion, I would like to state that Ms. Razrani would have never got into the contract if true state of affairs would have been known, and if she would have known that she would be paying 250,000 US dollars for 100 yapil instead of 1,000 US dollars for 100 yapil. So, would like to conclude that there is a mistake in the contract. And with that, Your Honor, this concludes my second submission for the respondents. I would like to invite your ladyship to reject the appeal of the appellant. And with that, Your Honor, this concludes my submission for the respondents. Is someone trying to speak? Excuse me.
No, please proceed.
So I would like to invite your ladyship to reject the appeal of the appellant, and with that, your ladyship, this concludes my submissions for the respondents.
Thank you very much, counsel. Thank you.
Your Honor, may I respectfully ask to submit my rebuttal on the second ground of defense?
Yes, please. Thank
Thank
you.
you. The respondent states that the mistake was unforeseeable and that the parties would not have entered into the contract due to the inflated price. However, and since the parties, including Ms. Razi, included to trade autonomously through a deterministic programming, the parties have implicitly agreed to trade without reviewing the contract terms. That concludes my rebuttal excuse me, sorry. I would like to also add before concluding that neither of the four conditions mentioned in the comment to the article in the Unidroit principles of commercial contract laws are satisfied, and therefore there could not be ground to avoid this contract according to Article 37(1)(a) of the DIFC contract law. Thank you.
Thank you, counsel.
Can the respondents as well make a rebuttal point? Is that
Please do.
Yeah.
I'm sorry, I don't think you're entitled to a rebuttal, respondent.
No? Okay.
I mean, that's what the rules say.
Okay. Because
Apologies.
in the earlier round, both the appellants and respondents were given an opportunity, but it's okay if we cannot. Thank you.
If I may just check with my co-judge how you propose to proceed. Okay, so thank you to both parties for these great arguments. I think I may speak on behalf of my co-judge also to congratulate both parties for their tremendous efforts. And I think you both did really well under pressure of the sometimes tough questions from the bench. So congratulations on that. I think the quality of your arguments for both parties was really high, and I commend you on that. I can see the great effort that went into preparing for this. I think you also both did well, as I mentioned, in answering the questions that were posed to you. And overall, I would say you both sides, all three speakers came across as relaxed, and hopefully you enjoyed this. And it was a good time, because at the end of the day, this is, just a bit of, it is fun. It's fun for us to be here, to take part in this tradition of mooting, which I did when I was a student as well. So thank you for playing along, being good sports. And I yield the floor to my co-judge for any comments.
No, I think I fully agree with you, Karen. The only bit of advice I think I have for, I think it's all speakers, slow your pace down. You're over internet. It's very hard for us at times to understand what you're saying if you speak too fast. I mean, I had to actually, at one point put my ear to the laptop to actually guess exactly what the words were, because if you went too fast, I lost you. You've lost the court.
I would also say that, just going forward for the rounds, don't worry if you get asked a question that you don't immediately have the answer to. That's perfectly fine. Even in real life, that will happen sometimes. And it's perfectly fine to say, oh, can I take a minute to confer? Some judges would say no. But overall, most judges would say yes, you could take 30 seconds to a minute to think about it. So, keep your cool. See, it all turns out fine in the end.
I think that's it from us.
Yes, thank you very much. I think we can adjourn court for now, and best of luck in the upcoming rounds.
Good luck.
Thank you very much. Thank you.
Thank you, everybody. Thank you
so much. Thank you for
Best
the
of luck
advice.
going
Thank you.
forward.
Thanks a lot.